Hello everyone, I am Advay Vora and this is SEO Explains. This week, or rather 2024, started with a significant judgment from the Supreme Court, where the court ordered the 11 men convicted in Bilkis Bano's gang rape case back to prison, quashing Gujarat government's remission orders from 2022. The Supreme Court came down heavily on the Gujarat government for abusing its discretion and acting in tandem with the convicts. 3 months ago, as 11 days of hearings came to an end, we saw silent Bilkis Bano in court, joining online as a spectator. Monday night, in a statement published as a response to the judgment, Bano said that this is what justice looks like, recalling and thanking the tens of thousands of people who have stood by her as she fought for justice. First, a quick recap of the main facts of the case. The story of the remission begins with an application from one of the 11 convicts, Radheshyam, who first approached the Gujarat High Court in 2019. Following the court's order, directing Radheshyam that the appropriate government would be Maharashtra, Radheshyam approached the Maharashtra government. With this application pending at various stages, afraid that the Maharashtra government was veering towards his rejection, Radheshyam went straight to the Supreme Court in March 2022. His ask to direct the Gujarat government to consider his remission application. On 13th May 2022, the Supreme Court obliged and the case was put before the Gujarat government. Just 3 months later, in an order dated 10th August 22, the Gujarat government released all the convicts who at that point had served at least 15 years of the life sentence. The government had relied on the Gujarat remission policy from 1992. Immediately after their release, Bilkis Bano and several other petitioners approached the Supreme Court to challenge the premature release on the grounds that the Gujarat government was not the competent authority to consider remission. The Gujarat government and several convicts dedicated a huge part of their arguments to the maintainability question alone. They were also against many PILs filed by third-party petitioners, namely Subhashini Ali, Mahua Moitra, journalist and activist Revati Lal, and more. Now for the decision of the Supreme Court on 8 Jan. In its decision, the bench held that the petition filed by Bano was indeed maintainable. The bench found it unnecessary to consider the maintainability of the other petitions, including the PILs, as Bano, the victim's petition was held maintainable. The bench then set aside the remission order for all the 11 convicts with two main reasons backing their decision. First, the meaning of appropriate government under the Criminal Procedure Code would be the place where the trial and conviction of the accused occurred. Bano and other petitioners had argued that as a special court in Maharashtra convicted the 11 men, the appropriate government to consider remission would be Maharashtra itself. The Gujarat government took a more territorial argument. As the convicts resided in a prison in Gujarat, they said that the prison authorities in Gujarat had a better idea of their behavior. The bench simply did not accept this argument. It reiterated section 432(7) of the CRPC, which defines appropriate government as the government of the state within which the offender is sentenced. Secondly, the bench held that the Supreme Court's order on 13th May 2022 was based on misguided facts. The bench held that Radheshyam withheld critical information when he approached the Supreme Court. He misled the court when he claimed that there was a difference of opinion between the Bombay High Court and the Gujarat High Court over his remission application. And so, Justice Nagarathna wrote that the May 22 judgment was obtained through suppression of facts. The bench found another reason why the Supreme Court's order in May 22 was incorrect. Justice Nagarathna held that the Supreme Court had itself erred by not considering a 2016 Constitution Bench judgment in V. Sriharan, which had held that the state where the trial took place would be the appropriate government. Interestingly enough, in 22, the Gujarat government itself had argued that Maharashtra is the appropriate government to take a call on the remission of the 11 convicts. However, after the Supreme Court order, the Gujarat government took it upon itself to consider the remission. Justice Nagarathna's bench reprimanded Gujarat and said that a lot of litigation could have been prevented if the state government had filed a review petition against the May 2022 decision. The bench found that Gujarat usurped the Maharashtra government's jurisdiction and abused the discretion. With this, we come to the last part of the judgment. Should the convicts who had now been released for over a year be kept outside of prison or sent back to jail? Should personal liberty of the prisoners prevail over the rule of law? The bench found the rule of law is above everything else, and that the Supreme Court cannot grant any liberty to these 11 convicts. Justice Nagarathna pointed out that the emotional appeal for liberty looks hollow, especially after the convicts abused the process set in law to get remission. The judgment reads, if ultimately rule of law is to prevail and the impune orders of remission are set aside, then the natural consequences must follow. The convicts were directed to report to jail authorities within 2 weeks of the judgment. For Bilkis Bano, this provided a hard-won relief to an arduous journey through the Indian judicial system to get the justice she demanded. In her statement, she thanked the Supreme Court of India for giving her, her children, and women everywhere this vindication and hope in the promise of equal justice for all. Be sure to subscribe to Supreme Court Observer on YouTube, follow us on Instagram and Twitter, and follow scobserver.in for all updates regarding the Supreme Court of India. Thank you for watching.